Good morning and welcome to the Maryland Public Service Commission's administrative meeting for August 11th, 2021. We have minutes to approve from our last meeting on August 4th, 2021. All in favor, please say aye.
Aye.
Any opposed? The meeting minutes are approved. Good morning, Mr. Secretary.
Good morning, Mr. Chairman. There are 9 items on today's consent agenda. Items number 1 and 2 are unbundled network element loop forbearance amendments to interconnection agreements between Verizon Maryland LLC, NRC LEC Inc., and Verizon Maryland LLC and Aris Inc. Item number 3 is an interconnection agreement between Verizon Maryland LLC and Aris Inc., Dish Wireless LLC. Item number 4 is a notice of transfer of control from Boomerang Wireless LLC to Via One Acquisition Company LLC. Item number 5 consists of revised tariff pages regarding 8YY access charge reform from bandwidth.com CLEC LLC. Item number 6 is a notice of voluntary relinquishment of operating authority from Legacy Long Distance International Inc. Items number 7 and 8 are from South Bay Energy Corp. They're both applications for licenses to provide energy, the first for electricity and the second for natural gas. And finally, item number 9 consists of updated standard offer service rates for type 2 customers from Baltimore Gas and Electric Company.
Thank you. Do commissioners have any questions on these consent items? Commissioner O'Donnell.
Thank you, Mr. Chairman. I have a question for staff regarding items number 7 and number 8, South Bay Energy Corporation. I noted on the buck sheets, both the gas and electric buck sheet, that there are, I suppose, the same 5 complaints referenced from New York State in the last 18 months. And I wonder if someone could characterize the nature of those complaints for the commission. Were they electric? Were they gas? Were they a combination of both? And what type of complaints were they? He's muted.
No. Mr. Albert, we heard you for a second and you're on mute now. We cannot hear you.
Okay, sorry, I pressed the wrong button there. Commissioner O'Donnell, we did look at that. The New York actually puts out a monthly report for all their suppliers. The best we could determine there was of the complaints, 2 of them were alleging deceptive marketing practices. And that's the extent of the, that's transparent as we can get on those. We also went to the Better Business Bureau website, and that indicated that 5 complaints have been filed against South Bay. 3 of those complaints alleged unauthorized enrollments, and 1 complaint made 2 allegations that South Bay failed to provide the gift cards that it had promised as an incentive to enroll, and that South Bay had not provided the promised cost savings that the customer was expecting. We have no, the Better Business Bureau website does actually have a copy of complaints. And so we looked at that, but overall the complaint in terms of the number of complaints was fairly small, as we noted in the buck sheet.
Thank you, Mr. Albert. I appreciate that. I'm not as interested in the quantity as the quality of the complaints and what they may indicate or portend. Is there a representative from South Bay Energy Corporation on with us today?
Yes, you have Brittany Hirson.
Hi, ma'am. Can you shed any light on the nature of the complaints referenced in New York State?
Yes, I mean, I can send you details on each if that's helpful at all. More often than not in these 5 complaints, it is due to 1 being coached by a different supplier, which is not something we encounter often, but it did happen 2 times out of these 5 complaints where customers were told to say one thing that wasn't necessarily accurate in order to acquire a certain deal from a different retailer. So those were diffused. The remaining 3, again, I'd be happy to send you details, but had to do with confusion between, for example, husband and wife enrolled, husband wasn't certain. We call up the customer. talked to them both and got to the bottom of that, if that's helpful to shed any light for you.
Yeah, it is helpful. Obviously, I asked the questions because our standards in Maryland for enforcement of these consumer protections are heightened and ongoing. And I hope that South Bay Energy Corporation is aware of that.
Absolutely, yes.
Okay, very good. Thank you, Mr. Chairman.
Thank you.
Thank you.
Are there any additional questions on the consent items? Seeing none, I would move that with respect to items number 1 and 2, that we approve the interconnection agreement amendments 10 days after a 30-day comment period unless adverse comments are filed. With respect to item number 3, I move that we note the agreement. With respect to items number 4, I move that we note the transfer of control of Boomerang Wireless LLC to Via One Acquisition Company LLC. With respect to item number 5, I move that we accept the tariff revisions for filing with an effective date of July 1st, 2021. With respect to item number 6, I move that we rescind the company's authority to operate in Maryland and cancel its tariffs. With respect to items number 7 and 8, I move that we grant South Bay Energy Corp. A license to operate as an electricity supplier with respect to item number 7 and as a natural gas supplier with respect to item number 8 in Maryland for the customer classes and service territories applied for and recommended by staff, and direct South Bay Energy Corporation to file notice with the commission within 30 days of any changes to the information in its respective applications. And with respect to item number 9, I move that we accept the revised tariff pages for filing with an effective date of September 1st, 2021. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
Aye.
and Commissioner Richard.
Aye.
I vote aye. The motions are approved. Mr. Secretary.
Mr. Chairman, item number 10 on today's administrative agenda is an interconnection agreement between Armstrong Telephone Company and Teleport Communications America LLC. On this item for staff, we have Afton Hauer and Kenneth Albert. The company's Kelly Fennell and Melanie Foley Music. And then also available are Fred Hoover and Joe Cleaver for Office of People's Counsel.
Thank you. Good morning, Ms. Hauer.
Good morning, Chairman and Commissioners. Afton Hauer on behalf of staff. On April 19, 2021, Armstrong Telephone Company and Teleport Communications America, LLC, filed with the Commission to request approval of an interconnection agreement in accordance with Section 252E of the Telecommunications Act of 1996, 47 U.S.C. Section 252. The agreement has an effective date of March 8, 2021. During its review, staff found 2 corrections to be made in the agreement. First, the definition of commission needed to be revised to the Maryland Public Service Commission. Secondly, staff recommended that Armstrong revise the unclear language in brackets under Section 7. On August 5th, 2021, Armstrong filed 2 replacement pages to the interconnection agreement in order to correct the errors specified in staff's comments. Staff believes that Armstrong has adequately completed the necessary corrections. Staff also believes that the agreement does not discriminate against any non-party telecommunications carriers because the terms and conditions of any interconnection agreement shall be available to any other requesting telecommunications carrier as required by 47 U.S.C. Section 252I. Staff also believes that there is no basis under the Act to reject the agreement submitted for Commission approval. Therefore, staff recommends that the Commission allow a 30-day period from the date on which the agreement is considered at an administrative meeting for
It sounds as if Mrs. Hauer was finishing up her recommendation and providing the commission with her proposed motion. Staff counsel, do you have anything further to add before we move to the company?
Nothing further.
Thank you, Mr. Albert. Counsel for Armstrong Telephone Company, do you have anything to add? Miss Music, are you with us?
Yes, nothing to add.
Thank you. Ms. Hauer, you're back. I thought you were just wrapping up. Did you have anything additional to say? Oh, she might
She
not.
might not hear us.
Okay.
I wonder if she's aware she was.
Do commissioners have questions of staff or the utility. Seeing none, I would move that we approve the interconnection agreement amendments 10 days after a 30-day comment period unless adverse comments are filed. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
Aye.
and Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 11 is a notification of debt issuance from Chesapeake Utilities Corporation. On this item for staff, we have Olivia Kirkendall and Peter Wilson. For the companies, Thomas Mann, Brian Quinn, and Marie Kozel. Also available for Office of the People's Counsel, Fred Hoover and Joe Cleaver.
Thank you. Good morning, Ms. Kirkendall.
Good morning, Chairman and Commissioners. Olivia Kirkendall on behalf of staff. On July 12, 2021, Chesapeake Utilities Corporation notified the Commission of its intention to issue up to $200 million of unsecured long-term debt securities and requested the Commission to note the filing. Under Public Utility Article 5-203C5 and 6-101C4, Chesapeake does not require approval by the Maryland Commission if the company had gross annual revenues of less than 3% of the total gross annual revenues of all Maryland public service companies for the most recent calendar year, and the company gives prior notice, written notice of the transaction to the Commission, and the company has obtained approval for the transaction from the appropriate regulatory commission in another state. Chesapeake's gross annual revenue is less than 3% of the total gross annual revenue of all Maryland public service companies for 2020. Chesapeake notified the Maryland Commission, and Chesapeake was granted the issuance by the Delaware Public Service Commission on July 14, 2021. Staff recommends the Commission note the filing. Thank you.
Thank you. Counsel for Chesapeake.
Good morning, Mr. Chairman. Brian Quinn, on behalf of Chesapeake Utilities. I have two witnesses from the company that are available to answer any questions you may have. And we obviously agree with staff's recommendation to note the filing. Thank you.
Thank you. Do commissioners have questions on this item? Seeing none, I would move that we note the filing. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
Aye.
and Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 12, the final item today, is a status conference in case number 9647 regarding Sunsea Energy LLC. Available today are Peter Wilson for staff, Jim McGee for the company, and Joe Cleaver for Office of People's Counsel.
Thank you. At the conclusion of our hearing on January 27th of 2021, the Commission established that Sunsea would file audit reports by a certified public accountant in the state of Maryland regarding a list of issues and tasks that the company was to respond with. I also stated at that hearing that there would be an opportunity for both Sunsea and other parties to provide comment after the filings were made by Sunsea. Those audit reports were filed on May 14th of 2021. And subsequent to that, Sunsea requested that the Commission schedule a status conference to address any remaining issues that the Commission may consider before tendering a final determination in this matter. We see that Mr. McGee, counsel for Sunsea, did file a number of pleadings, including copies of checks that were issued to former Sunsea customers. The commissioners have also reviewed the audit reports that were filed earlier this spring. So this is a final opportunity for all parties to provide their input, recommendations, and requests of the Commission before the Commission proceeds with a final determination to be issued at a later date. We'll begin with the company, Sunsea. Good morning, Mr. McGee.
Thank you, Mr. Chairman and Commissioners. For the record, James McGee with the Law Office of Robert Castro on behalf of Sunsea Energy. Jacob Aditwe, the president, is with me as well. Sunsea Energy appreciates the opportunity to come before the Commission to demonstrate its compliance with the Commission's order and to serve Maryland customers again. From the outset of this case, Sunsea has admitted and not disputed that it has violated certain Maryland regulations and the Maryland Telephone Solicitation Act. What should also not be in dispute is the immediate good faith efforts on the part of Sunsea to take action to correct these violations once notified of such and to comply with the Commission's order that it rendered after the October 7th hearing. This case started almost 15 months ago when OPC alerted Sunsea Energy of the enrollment issue with William Fields. Sunsea took immediate action and terminated the relationship with the agent it hired to enroll customers via telephone. Sunsea also immediately stopped the enrollment of any new Maryland customer while this matter got resolved. What was thought to be a one-time event, the parties, the Commission, and even Sunsea learned through this proceeding that improper enrollments occurred multiple times. However, Sunsea did not intentionally violate regulations, and they're largely stemmed from a misinterpretation of the regulations and law and a lack of control of its telephone agents. Sunsea unknowingly violated the Maryland Telephone Solicitation Act. Sunsea had acquired some customers through the telephone, with some of them being referred to Sunsea through its cable affiliate. At that time, Sunsea believed that that referral created a previous business relationship and exempted it from the MTSA requirement to get signed contracts. There were conflicting decisions from the Commission's Consumer Affairs Division regarding complaints against Sunsea on this issue, with multiple complaints decided in favor of Sunsea under the same factual scenario. Eventually, CAD seemed to settle on one interpretation that these referrals did not exempt MTSA compliance, and at that time, Sunsea stopped accepting these cable affiliate referrals from that point forward. Sunsea also violated the Commission's regulations on third-party verification calls, in part because they did not state an accurate rate. Rather, they only stated the price was variable, and then the customer received a contract and contract summary in the mail with the rate. Sunsea misunderstood the regulation and received several decisions of complaints decided by CAD that the TPV was proper, even though no specific rate was mentioned, and complaints were denied. However, Sunsea realized these errors and changed their TPV. Sunsea knows that it should have done better in making sure these violations did not occur and that Commission action is appropriate. As stated, Sunsea Energy voluntarily stopped enrolling new Maryland customers. It then became clear that the issues that Sunsea was having was from the acquisition of customers via telephone. As a result, at the October 7th hearing, Sunsea Energy proposed that as a penalty in this case, and as a way to ensure that none of these violations can happen again, Sunsea will accept an amendment to its license that it will not acquire any customers through the telephone in Maryland again. This not only includes that Sunsea Energy won't solicit any customers this way, but also that they will not acquire a customer via telephone even if that customer calls on their own and requests service. In essence, this is a partial revocation of its license and a substantial remedy that Sunsea had proposed earlier and continues to propose now. We believe that this relief goes to the heart of the matter and is the most appropriate to ensure that no future violations occur, whether intentional or not. At the conclusion of the hearing on October 7th, the Commission ordered that Sunsea do or do not do several things. First, the Commission established a moratorium on Sunsea for all marketing and all solicitation of new customers. Sunsea complied with this directive and has not marketed or solicited customers. Sunsea went a step further and maintained its original promise that it would not enroll any new customers in Maryland. The second directive, Sunsea was to return all customers acquired via telephone to SOS and provide a letter explaining such to customers, including a right to a refund. Sunsea complied with this directive and filed evidence of such with the Commission last fall. The third order, Sunsea was to re-rate and refund customers acquired via telephone the difference between Sunsea's supply charges and the applicable SOS rate. Sunsea has complied with this directive. At the January 27th status hearing, OPC questioned Sunsea's compliance, and the Commission also had doubts and ordered Sunsea to commission and pay for an independent third-party audit of the re-rate and refund process. And as the Chairman mentioned, Sunsea did file that re-rate audit report on May 14th, and we believe we complied with this directive as well. The re-rate audit report shows that there were errors, however, in the calculation of refunds, but they were generally of low magnitude and were often to customers' credit, where Sunsea actually refunded too much to the customers. There were, however, multiple customers who did not get a full refund, and as noted in the filing that we made yesterday, Sunsea has provided additional refunds to those customers to make them whole. They did not and will not seek any request from customers who got a greater refund that they should return those funds to Sunsea. The fourth directive from the October 7th hearing was that Sunsea is to send a letter to all customers about the violations found by the Commission, that they can return to SOS without penalty, and accurately described its green product. Sunsea complied with this directive and filed evidence of such with the Commission last fall. And finally, at the January 27th hearing, there was a question raised by the Office of People's Counsel that it wanted an audit to determine if Sunsea's contracts used for door-to-door customers were legally sufficient. There's never been an allegation or a complaint against Sunsea for their door-to-door solicitations or their contracts used therein. All the issues were 100% related to telephone customers. Nevertheless, the Commission granted OPC's request and required Sunsea to commission and pay for an independent third-party audit of its door-to-door contracts. Sunsea has complied with this directive and filed the contract audit report with the Commission. The auditor was tasked to compare the customer's name of record that Sunsea had as the name of record with the utility and the name listed on the contract with Sunsea. There were numerous exceptions noted between these two databases, but those exceptions were explained by the auditor to be misspellings, the first and last name of the customer in different order, or customer names that appeared on the contract but not by the signature block. There was one instance where it appears that a woman's last name on the contract used a maiden name, while the utility name of record was noted as her married last name along with the name of her husband. None of these exceptions affect the validity of the contracts. The auditor was also tasked to confirm signatures were on the contracts, and there were 2 or 3 instances found where no signature was obtained. The auditor also confirmed that the same standard contract was used with each customer. Finally, at the end of the October 7th hearing, the Commission found that Sunsea's compliance with the refund process will factor into the consideration of any penalty amount that the Commission may determine and calculate at a later date. This concept is consistent with one of the factors that the Commission statute on determining a civil penalty lies: the good faith of an electricity supplier charged in attempting to achieve compliance after notification of the violation. We think it's clear that Sunsea made good faith efforts like this as soon as OPC brought the issue to their attention through the CAD complaint process and in compliance with the Commission's October 7th order. Other factors the Commission considers is the number of previous violations committed by Sunsea. This is the first case involving violations before the Commission with Sunsea. The gravity of the violations is also considered. Here, Sunsea knows that it and the Commission cannot tolerate violations like the ones committed. And that's why it believes that the most appropriate penalty and relief for Maryland customers is to forbid Sunsea from contracting with customers via telephone ever again. This ensures that no future violations like this can occur. And isn't that really the core principle of a penalty, to deter bad future conduct? As to the civil penalty, what OPC and staff propose are extremely excessive and do not fit as a remedy of the violations committed here. Sunsea has righted their wrong at the Commission's directive by refunding customers every penny they paid Sunsea in excess of the SOS rate. Those customers have been made whole. Sunsea has paid over $66,000 in refunds. Sunsea has also not obtained one Maryland customer of any kind in over 15 months. And that's an indirect financial penalty levied upon Sunsea as well. In light of that, and of the mitigating and good faith efforts made by Sunsea to comply, requiring an additional civil penalty on top of that, coupled with barring Sunsea from acquiring customers via phone, would be unjust. And we respectfully request that the Commission find that no additional civil penalty is appropriate, and that Sunsea be allowed to acquire door-to-door customers in Maryland. Thank you.
Thank you, Mr. McGee. The commissioners may have questions of you, although we'll hear from Counsel for Staff Counsel and Office of People's Counsel first. We'll turn to Mr. Wolson. Mr. Wolson, we can't hear you.
Can you hear me now?
Yes, sir.
Okay, I'm sorry. Staff counsel has received and reviewed the third-party audit and has no further comment on that, and agrees with counsel for Sunsea that there has been generally compliance since this suit was brought. However, staff has reviewed the proceedings and the complaints and does not believe that it should alter its recommendations made in its prior testimony. That would be a $500,000 civil penalty and the revocation of Sunsea's license to operate in Maryland. And just briefly, although the reasons and the reasoning behind that was given in the testimony, we believe these penalties are within the commission's discretion. They fit well within the what's allowed in the regulations, which is $10,000 per violation per day. Here we had 1,248, I believe, refunds. And if one $10,000 penalty was given for each of those violations, it would exceed $12 million. In addition, that doesn't take into account, those were only complaints. Those don't take into account all the solicitations, which probably numbered in the tens of thousands, which did not result in enrollments, but were still violations because they contain misrepresentations. And we also believe that these penalties are in line with the commission's actions in the Smart One case, which was case number 9617, which resulted in revocation and a fine in the amount approximately of $500,000. Although Sunsea has made what appears to be a generous offer in stopping its telephone solicitations, staff would like to point out that allowing Sunsea to undertake door-to-door and person-to-person solicitations it creates problems in and of itself. Sunsea has a history of contract prices at unjustifiably high rates, often double the SOS rate, sometimes even higher. And those enrollments were achieved by making misrepresentations as to savings and through other deceptive practices, representing itself as someone other than itself. We have no reason to believe that a door-to-door solicitation would be any different, other than the fact that door-to-door solicitations are much higher, much more difficult to monitor because there is no recording as there is in a telephone solicitation. So for that reason, we do not think that is an adequate remedy. Finally, we note that the New York Commission has already barred Sunsea from conducting business in that state. And that was based on complaints essentially identical to what we were seeing here in Maryland. They brought Sunsea in after Maryland, but moved a little more quickly in barring Sunsea from conducting business there. I'd also like to point out that Sunsea had an obligation to alert this commission of those penalties and those proceedings in New York, and as far as I know, did not do so. Mr. McGee is correct that the regs and the statutes suggest that compliance efforts should be considered a factor in the penalty. And to that, I would suggest that the commission consider reducing the $500,000 civil penalty requested by staff by the amount of the refunds that were actually made. But for that change, I would suggest the $500,000 civil penalty and a revocation of Sunsea's license. Thank you.
Thank you, Mr. Wolson. Counsel for Office of People's Counsel.
Okay.
3 for 3 today. Mr. Cleaver, we can't hear you. No.
Mr. Cleaver, you are successfully unmuted, so it may be a problem on your microphone end.
Perhaps,
I don't know what's. I'm
there we
supposed
go. Oh, it's working.
We got something now.
Now you can hear me? Okay, great. Sorry about that. I don't know what that was. I managed to fix it in my settings. Thank you, Mr. Chairman, Commissioners. Good morning. Joe Cleaver for the Office of People's Counsel. Apologize for the technical glitch there. Thank you for the opportunity to speak today on this matter. Your Honors, at the conclusion of the October 7th hearing, OPC recommended a civil penalty against Sunsea in the amount of $2.5 million based on the company's repeated deceptive practices and violation of numerous statutes and regulations. After that hearing, Sunsea began issuing refunds, and at OPC's request, a third party audited that refund process. While the auditor found a number of what it calls exceptions, which are variances between the refund due and what was actually paid, most of those exceptions appeared to be for the benefit of customers. In other words, on balance, Sunsea appears to have paid more refunds than it was required to. Based on the audit report's indication that Sunsea had substantially complied with the refund requirements, OPC lowered its recommended civil penalty to $1.5 million. That's still a large penalty, and that reflects the seriousness of the violations. However, OPC's view is that lowering the penalty is appropriate in order to send a signal that when a supplier owes refunds to customers and it makes those refunds, that will be recognized in the determination of an appropriate penalty. The reason for this case is to protect customers. That's the reason we're here. That's the reason for the docket. So when customers who have been wronged have been made whole, there should be a reflection of that in the penalty. Beyond the current recommendation of a $1.5 million penalty, OPC also recommends that the Commission revoke Sunsea's licenses to do business as an electricity and gas supplier in the state. Mr. Chairman, you found at the October 7th hearing, at the conclusion of the hearing, at page 189 of the transcript, that Sunsea enrolled customers, quote, by deception. You also stated, Mr. Chairman, of Sunsea's owner, Mr. Adigwe, I did not find his testimony to be ultimately compelling or all that credible. Based on those findings alone, this is not a company that should be a supplier in the state. The company's history of deceptive practices poses a risk to Maryland utility customers and erodes confidence in the retail supply market, which I know is a priority and a matter of concern for this commission. Based on the record before the commission, license revocation is warranted under Public Utilities Article Section 7507K. One more thing to note, Your Honor, as you consider the appropriate penalty for Sunsea, with respect to the New York order that Mr. Wolson referenced, that order issued on May 18th, and in that order, the New York PSC revoked Sunsea's eligibility to operate as an energy service company. That's what New York calls suppliers, an ESCO. The New York PSC does not license suppliers per se, like we do here in Maryland, but the New York State Legislature has delegated to the New York Commission the authority to condition ESCO's eligibility to access utility distribution systems under terms and conditions that the Commission deems appropriate. And the New York Commission can also impose consequences for failure to meet those terms and conditions. COMAR Section 2051-0301 requires that within 10 days of a material change to a supplier's information, the supplier must file a copy of the updated information with the Commission. And one of those material changes that's listed in that regulation is, quote, the licensee has had a license revoked, suspended, or restricted in another state. And I haven't seen any record that Sunsea notified this Commission formally of that May 18th revocation of its authority to continue as a supplier in New York State. Maybe Sunsea thinks that the lack of a formal licensing process in New York exempts it from that requirement. But I would add, Your Honor, if that's the case, if Sunsea is going to apply such a narrow interpretation to a consumer protection regulation in violation of the obvious purpose of the regulation, that really undercuts the company's sincerity as to its promises to follow the laws and regulations designed to protect Maryland utility customers. OPC's recommended $1.5 million penalty and license revocation will protect customers, send the appropriate signal regarding the state's intolerance of deceptive supplier practices, and will bolster the integrity of the retail supply market in the state. Thank you, Your Honors.
Thank you, Mr. Cleaver. Mr. McGee, I will give you an opportunity to respond, but a few questions first that you may already want to respond to. But let me ask you, aside from the New York State Public Service Commission, is it a matter of public record that any other regulatory body has taken regulatory action against Sunsea since we last met?
And Your Honors, if I can have that question directed to Jacob Adigwe, if Mr. Adigwe can come on the screen. I don't know the answer to that question.
Okay. Thank you. Mr. Adigwe, if you're with us, if you could turn on your microphone and your camera. Mr. McGee, we see your client in the room.
Yeah, I see him listed twice. Oh, here we go.
Okay.
Good morning,
Mr. Adigwe.
Good morning, Commissioner.
Good morning, Mr. Adigwe. Did you hear the question that I just asked your attorney?
Yes, I did.
Thank you. Can you provide a response?
There is none in any other states.
There is no regulatory actions taken against Sunsea in any other state aside from New York?
Yes, but the New York State is currently being appealed, so it's not a final decision. It's currently in appeal.
Okay.
Actually, the case has been reopened, so there is no other case in any state.
Okay, I want to be careful, Mr. Adigwe. I don't want you to make any statements against interest. I'm going to turn back to your attorney now.
All right.
Mr. McGee, both Mr. Wilson and counsel for OPC raised this New York regulatory action. Counsel for OPC stated a potential violation of COMAR 2051-0301. What is your response?
To be honest, I'm not aware of what's happening in New York. And so I don't have a substantive response. I would have to follow up after speaking with my client, or if my client wants to communicate it, but I don't have any information on New York.
Okay, Mr. Adigwe, if you'd like to stick with us, with your attorney's counsel here, would you like to provide us with an explanation of what has occurred at the New York Public Service Commission?
It's clearly pretty much the use of an international based telemarketing center that also got us in trouble in that state. All right. Currently as we speak, we no more allow telephonic sales in every state. And now it's strictly pretty much person to person, door to door sales. That's what I'm basically doing right now. All right. It's just pretty much telephonic sales that got us in trouble in that state as well.
Did you share this information with your attorney, Mr. McGee?
No, I was never asked. I've been asked by the PUC or OPC about any open case in any other state. I was never asked.
Okay.
And take note, the Maryland case got filed. All right, started before anything transpired in any other state. Yes.
Thank you. I'll turn to my colleagues now if they have questions for any of the parties. Seeing none, Mr. McGee, I would like to just give you one final opportunity to respond to any other issues that were raised by opposing counsel.
Thank you. Just briefly, Your Honor. Mr. Wolfson referenced the number of what I think he meant were violations when he talked about 1,250 refunds and $10,000 per potential violation. The commission did not find that there were 1,250 violations. What the commission ordered was that because of the 20 to 30 or so complaints that were made by customers and the examinations through the hearing, you found it appropriate to give refunds to all customers. But there was no examination or finding that all of those customers were somehow acquired inappropriately. So I don't think it's accurate to construe this as 150 violations. Also, I don't believe that there's any evidence to show that Sunsea has committed any violation regarding door-to-door contracts. And we clearly admit that there's issues with telephone contracts, and that's why our taking the strong step of saying you can revoke, or however we want to say it, Sunsea's license as it relates to telephone customers. But there's no evidence to support that there's any issues regarding door-to-door customer acquired customers. And these, while there's no recording of what happens, there are contracts that are there. There shouldn't be misrepresentation about anything because it's in writing right there for that particular customer. And if there was a potential issue, somebody at some time would have filed a complaint, and they have not. 100% of the complaints filed before the commission were just of customers regarding the acquisition of telephone contracts. So we don't think it's appropriate that this carries over into really that side of the business that Sunsea has more of an ability to control, frankly. So we continue to believe that what we're recommending really goes to the heart of the issue. Sunsea has too many issues with telephone contracts. Don't let them get any more customers via telephone. That's what we're willing to do, and that's what we think is most appropriate.
Thank you. Commissioner O'Donnell has a question.
Thank you, Mr. Chairman. Mr. McGee, do you know where these, if there is to be a civil penalty in this case, just assume for a second there might be, we don't know yet, but do you know where those funds go when they're paid by a supplier?
I'm sorry, you're asking if you ordered a penalty, how does the commission use those funds?
Yeah, what's the statute say? Where do those funds go? I know the answer to the question. I just want to ask it for purposes of discussion.
Yeah, I don't have the statute open right now to tell you that answer, but
so they go, I'll tell you the answer. They go into a customer education fund to be used to educate customers about retail choice in the state of Maryland generally. And so the reason this whole construct exists is to improve the performance of third-party suppliers in the state of Maryland. And so the civil penalty goes beyond simple restitution. It goes beyond improving the entire climate in the state. And I wanted to hear your comment on that aspect, which hasn't been discussed today.
I can understand your position, and I also believe that it should go beyond restitution, and so does my client. That's where we get into the area of the partial revocation of their license, where they're not allowed to solicit any new customers. And so there wouldn't be any issue in the future with Sunsea on the telephone because they wouldn't be able to do it. I understand your global point of education to all customers, but drilling down to the specifics with Sunsea, I think it's more appropriate to go to the core of the issues, and that's what our proposal does.
Yeah, I understand, but it feels like to this commissioner, that you're saying retrospectively, we'll do restitution, and prospectively, we won't do telephone solicitations, but there's no penalty really that you want to exist for your client. And that doesn't seem like, to me, necessarily be in the best interest of the citizens of the state going forward. I acknowledge, this commissioner acknowledges the compliance, and so I think that is an important consideration, but it's not a dispositive consideration. Thank you, Mr. Chairman.
Commissioner Linton.
Thank you, Mr. Chairman. Good morning, Mr. McGee. I wanted to follow up on the proposal that Sunsea is making to limit the license for Sunsea going forward in lieu of other forms of penalty the commission may issue. The company already has door-to-door contracts. Are you also looking at leaving or using online marketing as well?
They have not historically in Maryland, and I'm not sure other states, used any online contracting. So their exclusive methods in Maryland were door-to-door and telephone solicitations.
Okay, so what's the company's status right now? I mean, if the commission were to accept the license limitation that you've proposed, is the company already training employees and moving forward with that option, or is this something that has to be ramped up?
I would defer to Mr. Adigwe on that. My understanding is that, that it would have to be ramped up because of the length of this case and really trying to figure out what the commission ultimately decides before taking action. But if Mr. Adigwe wants to clarify or provide more information, he's welcome to.
Yes, thank you, commissioners. Yes, they have to be ramped up. All right. First and foremost, we do plan to retrain all our agents to make sure they're up to date in regards to the door-to-door regulations. All right, before then they get ramped up before we go back, marketing in the state again.
Okay, so have you already developed training materials, or is this something that also has to be put together?
No, yeah, we've developed training materials, yes.
For Maryland?
Yes, yes.
Okay, thank you. That's all I have. Thank you, Mr. Chairman.
Thank you very much.
Thank you. Seeing no additional questions, the commissioners will take the information we've heard today under advisement. And we will be issuing an order sometime in the future to ultimately resolve this matter. So thank you to counsel, Mr. Adigwe, for participating today. This is the last item on the commission's administrative agenda today. For those who are staying with us, we will be having our pre-hearing conference in case number 9666 at 11 a.m. this morning. You could stay on this channel, or you could come back and join us at 11 a.m. With that, today's hearing is now adjourned. We are off the record.
Thank you very much, Your Honors.
For folks